and so they decided to ditch camp and not comply with the CI 127. That created an opportunity. Say, omoye tally sheet no omo fele candidates ni bibia. There will be a portion that they can sign or choose not to sign, but state the complaints of why they don't want to sign. And with that stated, it would have gone through the formal process of the, when it goes to the second level, the official who takes charge of the results will now have to address the complaint. And it was because they, in his own expression, they melted away when they realized that their presidential candidates, in order not to sign the document as required by law, neither did they have any complaint that they wanted to indicate. And also, Dr. Pesawa Itene Omo Anyadri. And that was it in terms of the summary of a year.
Within that period, I understand about ask and instruct eba app. On bench ni bemu.
Yes, because Professor Kote, Justice Professor Kote in Obemu, because I say witness statement, the word that was used was that they were asked to go and consult.
Okay.
But not say in his evidence, oral evidence to the court in the form of the questions or answer. He had used the word instruct at some points, and at other points he had used the word asked. To know Bisana say the important now person use. Now the response of mine is he uses them interchangeably, but what he means is that they were instructed to go and confer with their presidential candidate.
In the honor Prof. Carr said they are words that cannot be used interchangeably because
exactly they mean completely different thing.
So I'll share the dictionary meaning of ask as a verb. I can say something in order to obtain an answer or some information. That's the number one. For example, I asked her what she meant. So I'll share the second definition. I can say to someone that one wants them to do or give something. And Mary asked her father for money. Into two main, definitions of ask in the dictionary. And so we share instructing. So any meaning. Let's see. Okay, or say instruct as a verb. First meaning is say tell or order someone to do something, especially in a formal or official way. And number two, you teach someone a subject or a skill. And I think for the purposes of this conversation, the first one, tell or order someone to do something, especially in a formal way. It is also synonyms now. You will order, command, direct, tell, and join. And there is some clear difference between words. Me and just said an Prof. Kote drawn attention to.
But the point that Dr. Pesawa kept making was that he is referring to instruct.
Instruct.
Yes.
In which is order, command, direct, and join. There's a forcing is free honko. Okay. But the other bit about say enye or no and I'm casino name straight no and also
because a question was asked say within a period or a year electoral commission headquarters or no, did he have any direct interaction with the EC chairperson? So on the car, Bibi and on the Kitamubia, and Oka said there be. And see, Omubisa and the question is said, then how was such a person instruct you if you didn't even interact with her? Now, response on my end is a year Rojo Metununu Neko office on the Coding Common. Now, on any chain, Rojo Metununu be born a man, say, EC chairperson, I instruct you Musamunko, no money or more presidential candidate, echo confer. Now, what I'm saying is, what kind of information and discussion Omokako have here say Omumienu Ebekono? Now, his response was that because Rojo had gone to interact with the EC chairperson and he had been in the strong room to monitor the coalition, they took the view that by two of them going, it will give the presidential candidate a fair idea of the information that they had gathered from the EC chairperson and also from the strong room in order to give him a fair idea of what the situation was.
Oh, okay. And now I maneuver then the cross-examination basically. And Akutuampa so sorry. And also Ebusa then.
The cross-examination was very brief today. In fact, the point I would just make it to Mr. Amenuvo was to the effect say
Mr. Pesa White.
Yeah, Mr. Dr. Kwesa White was to the effect say, I mean, it wasn't the case that they were instructed and that they had the option of not going, and by choosing to go, it was their own decision to take. I want to say Dr. Kwesa White said to me, I disagree with yes suggestion that Mr. Akoto make, you know.
But initially, no, Ojitu say enya dia easy chair the bit me instruct one as an agent of a candidate. Right?
Sir Pepe, or agree with that particular point, lawyer no put it, you know. And after no justice ya okay, and now be heavy questions. Osign bemu and also obisa questions about Sasumaya, yes, ma say, and I instruct okay, you should Dr. Kwesa instruct.
Yeah.
Sign instruction ya osign bemu biom because no say on tiase. Because na dwimu de se obi asoma wo se kogina eho ye manam sini na woye mani maso bibibia wo na moye mienu na bibia si na obi ka se wo de kona woni we nkotwe nkoma na mo jai edwuma na moye na moko enti ho no still Dr. Kwesa White insist say na wa kire mu no omo instructing and they trusted the EC chairperson in that instance and acted out of good faith and went to confirm. Now, Sam Bemuka said, by doing that, no, it means that they didn't help the cause of the petitioner. At that point, now, Chachikata Bemuka said, the witness is being harassed.
Into that harassment comment, ni Bemu time Justice Apau. Able to questions.
Sir Pepe.
Okay.
Now, Oka says he's being harassed, no. Yeah, Justice Apau, Eka say like he takes exception to that description, no.
Okay.
Of being told that he's harassing the witness. But Mr. Chikata insisted by harassment he means that you can ask a question, but when you are forcing an opinion on his witness and still insisting on the opinion even though he's answered and explained the question, then as far as he's concerned the witness is being harassed.
And a opinion and they say Justice Apau say and
I think so saying that they didn't help the cause of the petitioner, in abandoning the work that they were brought there to do, to go and confirm because someone had instructed them to do so.
Okay. After Justice Apau, from the bench, no questions need for him by you in
in fact, it was during the Justice Apau, the questions now, Justice Mafusa still on the issues related to and our instructions here. In fact, CJ so Belmo at a point just to ask for clarification on the same questions that were being asked. So at that point, the center still on Sarah Sumaya and our instruction here almost say Omodema Dr. Kwesa White through Mr. Roger Metuno.
Akotompa can be said or free say the witness statement from Kwesa White, no, and share that in here and my petition on the case, no. Enti on questions non shada musa BBI.
In fact, was suggested to Dr. Kwesa White directly that the witness statement has not added anything to the case of the petitioner case. Because the petitioner's case is that no one had more than 50% of the votes cast. And that was the view that Mr. Kotampao took. But Dr. Kwesa White disagreed because he says his testimony is to the effect that mistakes that they detected made its way into the declaration because they were not given a fair hearing and they were deceived into going to confer with their presidential candidate in order to make way.
And one of such mistakes, Ashanti region,
Ashanti region,
still I was standing by Ashanti region over 300,000 votes. No?
In terms of the questions related to once or more bisan say, and no, a petition na enimno. In fact, bisan Akotampo bisan directly say. Or can say any petition or disagree can say at that point Mr. Kotampa remarked that the court will determine whether it is in or it's not in here.
Wow. And after the back and forth with the bench, and the cross examination lawyer Chachusi Kataka say only re-examination be to do.
And he was also asked, say, are they done with their witnesses?
Okay.
And a response on my end say in fact, Anopeya almost file some application be Anopeya. Anopeya file.
And an application for them.
They are asking to inspect documents in the custody of the Electoral Commission. They had filed it earlier, But the earlier one,
comparison between Wayne.
The difference between Wayne is first one, who file it to the other party as part of the discovery process. And say, oh, bisa say documents in the chain, my
Okay.
Now, nipa na responding into no afe is a formal request asking the court
seeking the leave of the
court to order the person that because the person has refused to give you those documents or allow you to inspect them. No, after you are coming to seek the intervention of the court that the court should order the person on documents.
Minya sa first way na. Who copy of the application.
Yes.
Okay. Fantastic. Now, yentimi and go through the specific document. The
they simply attach the earlier request.
Okay, and then maybe it's first year call earlier one. And
earlier one and then the list of the documents. First one, the originals of the constituency presidential election results collation form for all constituencies in Ghana.
Presidential election collation form. Constituency 275
in Ghana.
Original one. No?
They want to inspect the original copy. Okay. The second is the originals of the constituency presidential election results summary sheets for all constituencies in Ghana.
Okay. In the way, originals of the.
So one originals of the constituency presidential election results collation form for all constituency. Number and two near the originals of the constituency presidential election results summary sheets. It's almost a 1 year from 9 and 2 no stating as from 10.
From 10, okay.
It's a 1 year results collation form. Then from 10 then a year summary sheets no.
Summary sheets. No.
And the originals of the regional presidential election results collation form from 11.
Okay.
And the originals of the regional presidential election results summary sheets. And then from 12 for all regions in Ghana.
Okay.
And number 5 here, the original of the declaration of the presidential election results from 13. And finally, the records of the alleged update to the purported declaration of presidential election results on 9 December 2020 of the results of 4 constituencies in the Greater Accra region.
In our original application, no. Now, almost copies and also almost inspect.
In the original application, almost say to inspect and run copies of.
To inspect and run copies of.
But in this particular application, I may read the motion on notice. Now it says, please take notice that counsel for the petitioner herein will apply to this honorable court for an order for production for inspection of documents in respect of which a request for inspection was served on first respondent upon the grounds stated in the accompanying affidavit, and for such orders, as to this honorable court may deem fit.
And what it means is so we share latest application now. On person we inspect it. We no copies in count. Copies in count.
Yes, and in fact, we read in terms of the affidavit in support. Now it reads that on the 19th of January 2021, I filed on behalf of the petitioner and caused to be served on the first respondent a request to produce certain documents for inspection. Attached to this affidavit and marked as Exhibit Inspection 1 is a copy of the said request. A first respondent, it goes on to explain that the EC is the one that has the document. It goes on to say that the first respondent has failed to respond to the said request as shown in the search results attached to this affidavit marked as Exhibit Inspection 2. So they make the point that it is necessary for the originals of the documents related to the declaration of results to be inspected to enable me verify the basis upon which the declaration of results was made. In the proceedings to date, 2 versions of regional collation sheet for the Eastern region attached Exhibit D to the witness statement of Johnson Esiedu Nketia are in evidence, and counsel for first respondent in cross-examining him put to the witness what he claimed was the reason for the discrepancy. It would be in the interest of justice as lawyer for the petitioner I am able to inspect the originals of these documents, particularly for the purpose of cross-examination of the witness for the first respondent. So he adds that there will be no prejudice suffered by the respondent from the application being granted. This is the
and basis for requests. There was similarities to a similar one that happened in the 2012 petition. In the Anome Kai, Adinyara JSC, a ready court ruling on that application, then from the petitioners, Nanado and two others. Ama court no failed to grant them the request. In the area of argument be free because so far East lawyers see you opposed to this application. No, Nanado lawyers also opposed. And they will be given the opportunity to argue their cases out. Court no decided. So remember kwame easy the document no about anase omonfa emma. After no say no wie ntema na we will see Jean Mensa in the box.
But I mean what we've seen in the past is mostly no omu take an adjournment. They set the business when they are taking adjournment.
Okay.
And see, and right here, Ben, and you say Dr. Pesawite
never.
And see, it's likely that maybe tomorrow they will just deal with this issue because, I mean, obviously, let me say, Mr. Chikatabe movie motion. It may take a bit of a time. Now, in nature, response is never bad. Then the court would maybe take a break and come with a decision, or maybe take an adjournment to also come with his decision. And see, it is some year in the film. If the court is minded, now say.
I remember say Chief Justice Kai Obi Busa na mane say so mutimi wie motion in term
there then they will proceed to take that
to the next one. A lot will depend on this motion.
And I want to say Mr. Chikata Suasa indicated say in the event the court may grant your request now they may call further witnesses. They may ask leave of the court to call further witnesses because as it stands now, they filed just 2 witness statements. So they will need the permission of the court to file another witness statement to call the others, depending on if they get access to the documents non person inspecting.
Wow, that's really interesting. Argument to be free the other parties in opposition to this particular application. And I would want to believe, sir, they might all refer to the 2012 decision from
the court now documents no.
That be one documents. I think the reason the court gave mention if you bet me I refresh memories on that. Nano me kind waha and it was from Adinyera JSC and the MPP that be an MPP. Nanado Dr. Baumia and Jake the late they put in request also a EC copies of EC pink sheets and a coalition sheet in all the constituencies and polling stations across the country. The EC said no, and necessary because Omomu Free said the application from the petitioners is not necessary, it is oppressive and an abuse of the process of the court, and that it was not made in good faith. And easy for argument, and Supreme Court had the unanimous decision about say they disagree with the petitioners in the and I didn't JS in the really ruling, and this is the ruling. Or say the result collation forms and the declaration forms pink sheet hereinafter document are public records in the official custody of the second respondent. That is the EC. The petitioners as well as the first and third respondent, in this case, now John Dramani Mahama as the first respondent and the NDC as the third respondent because Omo apply to join into they were part of the case. Also, the petitioners as well as the first and third respondent, like all other political parties, are independent candidates that contested the presidential elections. Okay, and independent candidates that contested the presidential elections were given duplicate copies of the said document through their representatives at the polling and coalition centers and the so-called strong room of the EC in accordance with the provisions of CI 75. Or say, it is our thinking that where a party is already in possession of a copy of a document mentioned in another party's pleadings, it is unnecessary to apply or for the court to make an order for inspection and making copies of the document in question. By virtue of the Evidence Act 1975, NRCD 323, Section 166, the duplicate copies of these documents are admissible to the same extent as the originals in the custody of the second respondent. it continues, because the petitioners raised the issue of right to information as well as part of a more request for those documents. In the court, they say, this court affirms the right of all persons to information as expressed in Article 21(1)(f) of the Constitution 1992. This right to information implies a right to access public documents. However, it seems to us that the reliance on Article 21(1)(f) in support of this application is rather lame. For it is undisputed that the petitioners are in possession of duplicates of the said documents handed over to them and the other presidential candidates by the officers and agent of the second respondent, who is the official custodian of the originals, after the collation of the election results at polling and collation centers and the strong room of the EC. In the circumstances, we hold that the petitioners are sufficiently and well informed about the election result, which had enabled them to mount this petition on ground of malpractices in 4,709 polling stations. You remember, NPP4 produced pink sheets for all these polling stations as part of their case. And you are saying, based on the content of these duplicate documents in their possession, and on mount a petition. I say, the affidavit in support of the application does not disclose any need for the inspection and making photocopies of the originals of the document, and a refusal to grant this application will therefore not infringe their right to information under the said Article 21(1)(f) of the Constitution. The court ruling, basically, I don't know. And I think it centers on disclosing any need. And when you're able to satisfy the court as to the need for those documents.
And the need in this particular context, in the view of petitioners, sir, there was one instance that they have two sheets related to the Eastern region.
Okay.
And so they want to see the original to find out whether or not, I mean, it's the same thing that was used to be declared. But of course, the other question remains that does it affect all the 275 constituencies?
and the polling. Okay, so we're starting. Every polling, so many constituencies and about regions and national. And so affect all the. So
that would be obviously that would be the question, and so those would be the arguments. But I mean, clearly we'll hear a lot being quoted from this particular decision from the other side that are opposed to it, and so I mean they will have to lay the foundation. But this is what is stated in the Eastern region situation is the basis that is cited as one instance, and they said they want to have access, and they believe that if they are
from cross examinations, our question. Do you get the impression that petitioner will duplicate copies of all the documents? Has it come out
clearly? But so far, the point they keep on making is that they are relying on documents. In fact, unlike the 2012-2013 one where they had a lot of pink sheets attached to the petition, that's not the situation this time around. And so it's mainly the EC's declaration. So it may be a petition. They have one file that has the exhibits attached to it.
Okay.
The exhibits are submitted as evidence to the court. And see, me was our document. Okay, so I have it here now. Okay. So when you go through the document, exhibit, I'll attach it to petition. And the first exhibit B, a letter na petition EC chairperson before declaration, and a first exhibit attach a result summary sheet from the Eastern region. And I feel attach exhibit C, the declaration of president-elect instrument, CI 135. Exhibit D, 10th December press release from the Electoral Commission. And then exhibit D, exhibit E, so from the EC's website is Bunu East, so it has a summary of the various results from some constituencies and some regions. And I think so there's the presidential election results summary sheet over here for Techiman South. There's another for Infantimine. There's also Upper Dentura West and a series of others. So these are the ones that relate to the allegations of vote pardon.
Vote pardon in some constituencies. And this is something from the EC's own website.
EC's own website, no. There's also Exhibit F. And then here polling station pink sheet presidential elections 2020. Okay. Okaikwe North is listed here in this particular exhibit. It's the NNA attachments. So we don't have a lot of pink sheets like was the situation in the 2013 petition.
No?
Yeah.
But one of our reasons for our request, because Electoral Commission publish a constituency collation summary sheet on their website, right?
Yes.
A woman person when they compare the EC website.
It reads specifically, sir, in the proceedings, first respondent has filed an answer to the petition under the hand of its chairperson, to which are attached copies of various documents, including a document purporting to be the Form 13 relating to the results of the presidential election. It is necessary for the originals of the documents related to the declaration of results to be inspected to enable me verify the basis upon which the declaration of results was made. It says in the proceedings to date, 2 versions of the original collation seat for the Eastern region attached as Exhibit D to the witness statement of Johnson Esiedun Ketia are in evidence. And counsel for the first respondent in cross-examining him put to the witness what he admitted was the reason for the discrepancy. And it would be in the interest of justice that as a lawyer, and so can I announce the Eastern region, or can I say there was one constituency that had been left out.
I think that was a soldier man, right? Yeah, a soldier man.
There was one or can I say even Mr. Kutampa man or they subtracted our results just to demonstrate.
Okay. In the Anono say one fundamental reason or more cited for this particular request. And I believe the court will be seized with argument from both parties. Now, from all the 3 parties, no me decision about on this particular ruling. The final one after some press conferences then echo so in the petitioners need the back so na second respondent team so eba kasai say utie petitioners na major concern from any proceeding then
for the petitioners no there almost say was a good day in court in that more witness no more evidence it couldn't be contradicted, and as far as they are concerned no a supporter case say obi more than 50% of the votes cast. But on the side of President Akufo-Addo the team there almost say as a stories now insist so now as far as they are concerned no in terms of the exposure now they are being exposed no, and then also in the form of this story about being sent to go and confer and abandon the work that they are supposed to do, and see both sides in the close of proceedings no they hold a view that they had a good day in court.
Petitioners who were not enthused about cross-examination from the bench almost say so almost means still say harassment.
Almost say harassment. That's the view that Dr. Ayine still took in repeating. The only difference is say unlike the colleague Chachikata are any harassment in there. Not say justice here upon harass the witness. No. In the instance of Dr. Ayine, one will be a demo. Just can say I mean the witness also the witness was being harassed. I mean him so referred to bench now and I say
but in practice as a journalist reporting from the court no unusual say after cross-examination bench and so will take their turn to cross-examine witness no.
I mean in fact sometimes it's not even, in fact we've seen it even in this instance, it's not even after the cross-examination. In the course of sometimes lawyer need bisa question because the panel sometimes comes in to also ask the questions, and it even happened time Mr. Esiedun Ketia testify and justice here bisa the 3 questions now trendy and round. But the concern that Mr. Chikata had on this one is say or say the opinion of the judge. It's not the judge can have his opinions, but he shouldn't force the opinions on the witness, especially when it's not a question that he's asking. And the opinions relate to the fact that he didn't help the interest of the petitioner by abandoning the work. That was the concern that he had. So in terms of the practice, it's not very unusual, and we've seen it play out in this particular case that the panel comes in sometimes during the cross-examination itself and even at the end to ask questions of their own.
Joseph Akable Mayanase.
Yeah, Mr. Medase.
Yeah, that's a pa. Yami shouting. Yami adu much na besan so Eddie and come. So we all wait for tomorrow. Ma yenye a bit more legal education lawyer nana eje bafo ewa private legal practitioner and right any din komo and then so me ensign kwane ho lawyer akwa ba na pom to saying Great. Ma yenshasye emfree one issue ebe contentious, especially after any hearings na members on the bench omo try say omo so cross examine witness no my issues by lawyer Chachuchi Katasoreka say ofili say and the witness is being harassed by one of the justices. Normal say justices no ebe cross examinations. And sometimes we say na questions ne bar repeatedly. We can we the diaba na we the diaba. Is it normal? Normal, sir.
The patrol no any cross examination. We are seeking clarification. So say oh yeah will be a cross examination. Normally no it be a witness no they can assemble you be emi now. So to one judge chrono
Ekosiisen on Asempa FM
questions be wanting to clarify adia baako mmienu bi a sabi esie. So na ebi a judges we no there they decided say they wouldn't want to interrupt the flow. They rather wait till say adia no yibi ansa na omo bebem. Na wo adia baako a wan wi a ebe ni pay adwene and he said, I almost said the system is so adversarial. And you know, if it's an adversarial system there, then it is about the judges folding their arms, watching the parties banter.
Yeah. And
then whoever comes up at top. But they are forgotten. The system has changed. Our litigation system now, it is more pro-justice than Sebi, open to me, I did the imagination, now I did the Amna, we keep I that tell you, could there be a new tina, you want tools to say in time, to say a friend is saying, discovery, the patriotia here. If you say, no, you practice, no,
Ekosiisen on Asempa FM.
You will send them who you the patriotia here. If you say, adia na wo kanu unimu no koreba na wo de asie so ta say
yes
enti udi sia e san said ye wo de asie na wo po na tini minti no na wo de na stand out na wa so see no the litigation and move away from there. So enti you don't do ambush litigation judge enti bi asia ono ni atemuafo no enti obetu bisa question obisa question a who
but the other thing is yes, judges know who quite so a question for clarity. But shouldn't we also look at the form of the questioning? Into yes, substance the one may say up a clarity obetimi ebusa. But the form, for example, lawyer Chachuchi Katasoreka said justices never air force in the opinion on the witness because no what track question after in your opinion no person witness ni jetum in the yenhwe form then so
the part of form no so necessary a to the bia yen can say judges in see nipa
Ekosiisen on Asempa FM
bibi sabi to me see na istia eno say she eno ne say ube prompt no so but to say be all harassing on the idea, well, sometimes people say I'm go too far. So I can
say. The other thing would be say Osha the cross examination of Pesa White by Electoral Commission lawyer now. Sitting back at Osha cross examination, no. Now, easy lawyer na person achieve then. What was the end game for him? So I will compare cross examination to the issues are court and set it down. So we and I as far as this petition is concerned. Now end game they are then for him.
If I told the technique, the cross examination technique, the easy lawyer no use to your friend is saying you are pulling the witness by the nose. You are pulling the witness by the nose. And then in the day, And when they say, you get him to agree to everything that you are saying. And by the time you know, now, as when they say, the conclusion I want to say to him, you know, is the only inevitable conclusion. The part what I said is the only inevitable conclusion. And he said, even if he says no, any reasonable person following the cross-examination will agree, say, or no crown would intro. Now, from where I said, he wanted to demonstrate that, and some are not all canon, not only the all can. Some are all better testify, no, say, and come on, is he will do no matter, they easy, my men and terminal, not only all. And he or no crown on your competent witness. That's what I said.
Yes.
The Bisana no person watch.
And with the benefit of hindsight, and yes, you must be access to witness statement no until any cross examination no started. But it seems a lot of the issues therein no issues are a war in the personal knowledge of the witness. And
exactly.
In terms of even forms now, no almost say. Obi sign ya na, obi certify ya na a rojo metal no certify in terms of that communication between agents no any chairperson of the commission rojo metal no enti na e was metal no mum na ye witness na
but he was a more competent witness, so he would have ordinarily been a more competent witness in this matter. But don't forget to say na omumienu no represented John Mahama. So in terms of the documents, maybe I'm sure say he could perhaps have spoken to some of the documents. But in terms of conversations that took place in his absence, so then the person or the moment to testify to it. So then, in terms of even the documents, to the extent says Rojo metal SI, so then Rojo metal assigned there. How not say Osaba na say Opeso yet to say there will be answering on this idea. Then it casts doubt about your credibility and your real intention, right? As far as your place as a witness is concerned.
The other thing would be, sir, because sir almost spending a lot more time on sir instruct any ask any sadie no. What can say Roger Metal no because say on no and allegedly maame no e can asem ne kire no and kono will be a more competent witness to respond to that particular see how would the court prove if indeed Sadia and course or answer and if there was an instruction? Okay, I think I didn't use the right word. It should not be proof. Indeed, how would the court adjudicate on that specific issue?
It simply means that the allegation you made, you couldn't prove it, and so the burden on you to prove say. Asema wokan no kre anase nye no kre no what feeling in that what feeling went me on the charge. And now there is nothing on the side of the respondent, the first respondent in particular, to show say asema wokan no kra obwa.
Now wama circumstantial evidence be there because okay say omuja omo cars so enu to omo for omo cars anko enu to omuja omo laptops any ade ewo ho enye enough circumstantial evidence.
Wadama, wa metre so far no bibia ni wa ebeda court running say any more can say ujai no in to begin with ujai ho o bibi by
dabi.
Secondly, say ujai wa laptop ni ade o wa who can go into your mind to know why you left your laptop? Shakespeare said that there's no art to tell the mind's construction on the human
on the face.
So what I said. It is better. So, thirdly, sabi empenyefo mienu ena na judges ni bisa no. So, ena na judges ni bisa. Me ya kwala na me hwe me nana shop
Asempa
e
FM.
ɛna maame bi baeɛ na ɔse watɔ nneɛma no bi nti yɛni n'akyi na yɛnkɔ gyi sika no mmra na menkoa na mewɔ shop hɔ ɛna medi n'akyi yɛ dɛn ɛkɔɔɛ ɛna metoo shop no mu ɛpa kyɛ ɔte aseɛ yɛduru maame no fie no ɔse ɔɔba wɔho na menkɔ shop nkɔ yɛ sɛ mebaeɛ no wɔkɔ mepa kyɛ ɔte aseɛ ɛnti sei no mpanyinfoɔ mmienu a mu mmienu yɛse yɛte adeɛ agya mo
on Asempa FM.
na mu mmienu nyinaa mo afiri hɔ na asɛm no na nipa baako ntumi nkɔbɔ ɔmanpanyin ma dɔma ama amaneɛ.
They raised the issue of good faith. Say na omutsi mu fine say yes waka and yate de wo kana asopem in the kwaba na issues be will be resolve it. Good faith was the point they raised.
So the pastor but this what did. Yeah, but Twabano was it not clear enough?
Asempa FM.
Among NBC 40 easily. The pastor consistently did that not become clear?
Yes.
In the air suddenly what that could be also be easy nipa consistently what say we and after the opportunity then nipa mienu eti nipa mienu no na baako ntumi entena ho e ma baako nko
But don't you also think sir at a point, yes, you might have mistrust, but in the interest of the process and making sure, sir, because you are too aberry, there should be a declaration. Okay, I get you.
Question baako pɛ na ɛsɛ obisa wo nti nipa baako pɛ ntumi nkɔ nkɔkɔ president Mahama amaneɛ.
I get you.
Nti nipa mmienu nyinaa na ɛsɛ ɛkɔ.
The other bit would be say yen nyinaa yetimi resolve what actually happened on the day. Say na a instructional, na a asking, na a den a resolution of sa issue no. How significant is it to case at that court in the name CCR?
If I told you, the answer we are made prejudicial.
Okay.
So they are saying,
yeah.
Yeah. Because for me, so look at the issues our court is settling down. Maybe I won't say even if
Ekosiisen on Asempa FM.
how does it resolve the issues our court is settling down? So taking into account the fact, say elections, ya two ama yabobo abano various police stations any quality of coalition centers and they are called regional coalition centers ama signatures behind the ACOSWO. So it is even if asema all cano see a different say a pa a better Sunday exit from the regional to the police station nana.
Okay, but no is an interesting point you raise. At the end of the day, say Oshe one of the issues now. Issues no bako and say did any of the two leading candidates get the more than 50% vote, valid vote, pursuant to 63.3? And I know one of the critical issues. The petitioners argue, say, concerns about the elections, for which reason I don't pursue munya audience with the commissioner. And the commissioner and some almost say omun presidential candidate, and then yes, our discussion now omun saimra, no omun share the way forward out of the issues, no. Sa nyomo muhu yeno was material in effect, as far as Obia Obe crosses our 50+1 a header, no, it is not a straightforward idea, sir.
Information or more can information
Asempa FM.
What if you know qua afa and I say almost was information and I information be so say and then one of the things about up in their press conference and they say there are documents that are sanctioned by the regulations that govern the elections.
Yeah.
Some documents will be out. And we share the cross-examination of Mr. Justin Amadubo Esquire. Or get the witness to admit to those facts. Okay. Say election, you're to the police station.
Yeah.
Say aye. You're to the police station. Yeah. Your mouth. Yeah. A friend is saying statement of results maybe. Or say aye. The patrol. There will be a signing. Okay. Say aye. The patrol just had a CA. It is a sign CA. Not a war. Fast statement of results and a pink sheet media. So, would if equity original, who keep photocopy, or other stakeholders keep photocopy. So, so far, no, what dear way? What dear way? Into the country and say, a beer, who shall pin sheeter? The easy the back one, in so. Not the easy bontina or see a mistake, and then the witness so. It is an easy corrective we are dealing.
Ekosiisen on Asempa FM.
Yeah, because Ebia Omodia Wahino might not suffice because of the nature of their case in court. And the nature of the case, no. Yes. Okay. I get you, but I just wanted to read something out. Na etimi aboa yenyina we the lawyer Sami Jemfi a posted on Facebook or say the main purpose of Dr. Kwesa White's evidence was to demonstrate the bad faith, lack of candor, and due process displayed by the returning officer of the 2020 elections. Mrs. Jean Mensah in the coalition and declaration of results in clear violation of Articles 23 and 296 of the 1992 Constitution as pleaded by the petitioner, and he did that in a brilliant way. In somewhere, Same editorial, putting that witness out, at least from petitioners, not omo bibi omo person omo achieve. Say Ghana for nyina be hu say is any a major stakeholder like the NDC and Sheda Nini as far as the presidential elections is concerned. Lawyer Kutuampa also is of the view say witness nankasa witness statement and Sheda relevant to the issues before the court. And you will be saying the question back pepe ena oma etwa so. Assessing the two positions, as a private legal practitioner, as I was saying.
As to whether or not say they all can or move to me achieve and I just make determine.
Yes.
The cross-examination from the respondents' lawyers, and no, and to bring in maybe out. Said Yena not Yeshibi. The Patriots say Yena Yeshibi. Question is whether or not they are all canon. Sani move. And I say Omo intimi achieve sano. The Patriots Yena Yubi. I'm saying, we are judges. We could judge for ourselves.
Yeah.
What I say.
Okay. Enti ma minji sa
on Asempa
education way so sisiano court no was adjourned today to tomorrow. Say application petitioners no ediaba a motion for to request for some document, inspection of some document from the first respondent. Minim say in such trials, no before the trial and start, no, your discovery phase. So you discovery phase, no case management, ni BBA, cause na trial and kasasha. So within the trial, no, obi to me a file application in the nature of a discovery, and
Actually, yeah, na adding. So because discovery there,
Asempa FM.
say you do it before the trial. I say. And yes, a trial may cost and now baby such application. Ain't no one year a multi-year thing, but if you're seeing it, Supreme Court this year approach, So, Ocean Yama or Mubisa, original copies of certain documents.
yes.
Ekosiisen on Asempa FM.
Let's see how the court will approach it. Why?
Okay. Lawyer Auntie, what we'll do is
Yeah, Ochinano.
yeah.
Jamebo Ochinano. Na, yeah. So,
Yeah.
we can have a discussion around it
Okay.
about the propriety or otherwise of the court decision.
Of the court's decision. Okay. I hear you. Ain't ya the best seat na ya train ya me ya dumo awchina. Why?
Not why.
Me da se papa nyame shra.
Adanke.
Lawyer Nana Ejay Bafo Ewa private legal practitioner na moten nka Ekosiisen so ni high Asempa FM. Ain't lawyer for me no na ebeka yensa e studio ha. One from the petitioners camp and the other from the second respondent camp. In the Ebenya lawyer Henry Nana Boache Ewaha, or one of the spokespersons for the second respondent in this election petition. So lawyer Kojoga Adawudu. And so one of the spokespersons for the petitioner. And lawyers mienu na ebeka yen ho na afei ya hwe ede in komono atwaso. O messages no